Hey everyone, welcome to episode 159 of the Immigration Lawyers Podcast. Thanks for joining. We have a great episode today. We're doing a group interview with David Malik Telfer, an immigration attorney in Los Angeles, and Brian Green, located in Colorado. David and Brian worked together to file a few O-1 lawsuits that worked out really well. So I wanted to bring him on to talk about that. But on a side note, I individually did a CLE type recording for the Immigration Lawyers Podcast premium page, which each of them with their specialty. David got O1s for musicians, and that's a great series. It's an hour and a half that with Jerry Marshall and Jeannie Doy going into the details of that, but also with Brian Green breaking down the beginner aspect of filing a federal lawsuit. So if you're interested in that, you could join the Immigration Lawyers Toolbox. Email me at info@immigrationlawyerstoolbox.com to get more information about that. These CLEs will sold individually as well. If you want more information or the link for that, just email me. But for members, they get all free, the basket of all the CLEs and videos and information that's on the website. Secondly, I just want to remind everybody that DocuWise, a fabulous software that I use for my immigration forms, is a sponsor of this podcast. And they've been kind enough to provide a special deal for listeners. If they go to www.docuwise.com/immigration-lawyers-podcast and enter the code Immigration Lawyers Podcast, they get 10% off an annual plan, which is already discounted from the monthly plan. And DocuWise is a great all-in-one immigration form and case management software. It automates collecting information from clients and populating the forms, which is really good. You just put a phone number at once and it goes everywhere. It has multilingual questionnaires that can be shared to any device or text. So a lot of you have clients that may not use the internet. They have that text option, which is wonderful. And it also has a full suite of case management features like invoicing, trust accounting, calendaring, document storage, case tracking, and a lot more. So it's definitely something, at the very least, you should do one of those sessions where they go through it with you. Just go to the website and test out the software. They'll have a person go through that with you to help you out more. And I really think it's worth it to look into the switch at the very least, if not jump in and get that yearly plan. And with that, one more thing. If you're listening, wherever you're listening, leave a review, leave a 5-star review on iTunes and all that. It helps promote the channel so more people can learn about this program. And with that, let's get it started. Hi, everyone. Thank you for joining us again on this great episode. We have two great colleagues, Brian Green and David Telfer. I've known them both for a while. David a little bit longer, a longtime listener as well, so I really appreciate that. We're bringing on board because they've both been doing work together on O1 related federal lawsuits and have had great success. They've shared it on the listservs. I'm sure you all have seen it, but I wanted to bring them on so they could talk more about the procedures they went through, the hiccups, or everything that's involved with it. So y'all could also be more comfortable in these situations, because lawsuits are the next frontier, and that's what we have to deal with under this administration. And the elections are happening a week later. I'm not very optimistic that things are going to change. At most likely to get worse. So you have to be prepared for federal litigation. Thank you both for coming on.
Yeah, our pleasure.
So Brian,
thank you.
Let us know a little about yourself, and then David, just to have a background of kind of work you do.
Sure. I actually started off in the litigation world and as a trial attorney. So when I came out of law school, I didn't speak Spanish and I didn't have an offer to go work for, a big fragment type of law firm. So I didn't go directly into immigration that I wanted to. I started off working for a trial court judge, writing opinions, working in the courtroom with evidence and working with juries. And then I was a public defender for a couple of years in West Virginia, trying cases, being in front of juries. And then I took my dual license Pennsylvania, West Virginia resume with me. And I started defending General Electric Company and General Motors in toxic tort lawsuits and product liability lawsuits in Pennsylvania, Ohio, West Virginia. Did that for a couple of years, working for an amazing lawyer who's now a senior federal judge. And eventually I got into immigration. And the way I got into immigration was, hey, I'm a litigator. A law firm needed a litigator to do a lot of Mandamus lawsuits, a lot of APA lawsuits. So I sort of transitioned full-time into immigration back in 2007. And I've been doing, for the past year or so, I've been trying to do exclusively district court litigation. And I met David through a couple of mutual mutual friends. We've had a lot of good cases, and as David will say, even the best lawyers are getting denials now. So when you get those denials, going to federal court is the best resolution for me. And I'm enjoying working with lawyers across the country on lots of different immigration-related lawsuits.
Awesome, Brian. Thank you. David, how about yourself?
Yeah, so I originally started off, I started off at a big firm, and I was actually in estate planning, which didn't really work for my personality. And I went off into some other stuff for a little while, came back to law and got into immigration. I opened my own firm a number of years ago, and we mostly focus, we don't do any removal defense at this point. We mostly do, business and family immigration. But we have a real focus on entertainment immigration, and we're here in Los Angeles, and I worked at a big entertainment law firm prior, so it's kind of a natural fit for me to fall into. And then, yeah, I just went based on everything that's happening, and it got to the point where it didn't matter how good our case was or how well we prepared it. There were some cases that were just being denied. And so I reached out to Brian. I heard about that Brian had been doing a lot of litigation, and the beginning of my immigration career, people talk about suing in district court and federal court. It sounded so incredibly overwhelming and frightening, and I was like, I'll never ever do that. And now it's like, day in, day out, we're suing for people, and it's been great. It's been great. Brian co-counseled with me on the first one, and now we've been doing a bunch for a lot of other attorneys in Central District here in California, soon to be Northern District too. And yeah, we've had great results for people, really fast and amazing results that I don't think there's any other way to get that type of result. So it's been great.
Cool. So tell me about that first case that got you both together. What kind of facts were there? What happened?
Yeah, so I had my first two denials that I've ever had for O-1s. They're kind of almost back to back, and
they're great, interesting. They're death metal, and it's music and recording, right?
Yeah, so one of them is a producer, hip hop producer who does beats for all sorts of people, that you've probably heard of, and the other guy is a tour manager. Mm-hmm. So a lot of, for a lot of these O-1 visas for musicians, it's not always the musician themselves. A lot of times it'll be their tour manager, production coordinator, things like that. Mm-hmm. So he's a tour manager for a bunch of big, metal bands and things like that. Big profile people, and this guy actually had it was like his fourth O-1, and I guess we just got a rotten officer. The evidence was incredibly good in the case. Like, there was I don't think they liked the structure of our petition, which I'd actually kind of warned the client, like, hey, this is not their favorite structure, but is all he had at the time. But it was completely legitimate.
Could you go into more about what you mean by structure?
Yeah, so there's different ways to structure the O-1, right? Like, you can have what I call a petitioner employer. Basically, the petitioner is the only employer. You can have a U.S. agent petitioner and multiple employers, or you can have a U.S. agent petitioner and a foreign employer. Mm-hmm. In this case, this structure I use a lot as a foreign employer, but the petitioner, there's no requirement. The petitioner in this case was not in the industry. And I think for them, that set off some sort of alarm bell for them. And they thought, oh, this is not legitimate. But I knew that would possibly be the case. So we submitted letters from all the employers of the employer, right? The companies that would be using his foreign employer. Yeah. So it was very bootstrapped, there's plenty of evidence. Anyhow, they just
that kind of stuff. It's pretty open-ended on that kind of stuff, right?
Sorry, say that again.
The regulations are open-ended with regards to like the O petitioner, employer, foreign person. There's no regulation directly against that, right?
Yeah, and this is exactly by the regs, right? This was like word by word by the regs. It's a structure we use all the time, but typically we try to use a petitioner that's some, either like management company or label or somebody who's like really clear that this is not like made up.
Friend.
Yeah, that's not a friend or whatever. This is a third party company This is not necessarily in the business, but it's completely legal by the code, and we were very transparent about what it was. And we even bootstrapped because I knew that could potentially come up as an issue, that they might not believe that he had real work to do here. So we bootstrapped with some extra evidence that we normally would not have added. And they didn't really even focus on, they tried to focus on that in the RFE, but we beat them back because did it exactly by the regs. So they knew that they lost that argument. And so they just focused on extraordinary ability. But this is a guy who's been the tour manager for some of the biggest bands in the world, has articles. Tour managers don't normally have articles about them. This guy had articles about him. He had, I mean, you know, it was his fourth O-1. It was just like completely preposterous. And I thought, well, all right, sounds like it's time to call Brian Green. And and I was like, let's do it.
Yep.
And that was the first one that we did.
And the AUSA asked you, like, was this his first case or has he had prior approvals before? And David's like, yeah, this guy's had multiple approvals before. CIS is obviously changing the rules now. And the U.S. attorney didn't want to look bad in court, and they reopened and approved the case for us.
Now, you kind of jumped ahead. So you submitted the case. You know, how much work is the argument or paperwork involved in making that? Is a lot of it just, you know, providing the RFE response, all that kind of stuff? How much legwork is it to file one of these?
Yeah, I mean, I can tell you from my perspective, and I know that, like, you know, Brian's reminded me on a number of occasions that we don't have to make our entire argument in the complaint. You know,
David's arguing summary judgment in the complaint. He's putting every detail. He loves the weeds. He loves the nuances and the regs, and that's good because the AUSA doesn't know anything about that. We know the immigration law. They know procedure.
Yeah. So as Brian is like reminded me on a number of occasions, like I could go a little more skeletal, and like this could be for later in the process, and like he knows that, he understands that much better than I understand it. but when I submit it, I want it to, you know, in my head I'm thinking, okay, I want the U.S. attorney, when they see this, to go, this is crazy. I don't want to deal with this. And I want USCIS to see it and realize how weak their argument is from the get-go. And maybe I'm wasting some time by doing that, because it does take a lot of time to really develop a strong argument. No matter how strong the RFE was, I mean, I'll back up a little bit. The way that I respond to RFEs now is based on these complaints. So it's a little bit easier if it's one of my underlying cases. But when I'm doing this for other attorneys, or we're doing this for other attorneys, it's a lot more work, because they're not making a legal argument most of the time. They're getting into this tit for tat facts issues. And so my argument's actually very different than what they have responded to with the RFE. So it's a lot of work just on the complaint side, not to mention all the other, you know, the supporting docs that go with it.
Yeah, I would say
it's a legwork. Yeah.
Probably I'm a true solo, so I don't have a paralegal. And if I have to do a complete lawsuit beginning to end, you know, a simple lawsuit, if I have all the documents, I could probably prepare everything in maybe 3 or 4 hours. And then if you're talking about a lawsuit, like I do EAD delay lawsuits that are very similar and structured. If you have those, I can do a lawsuit in under 2 hours, but that's very templated, pro forma. If you're challenging the denial of a benefits case, you have to get into the nitty gritty of what did they say in the RFE? What did they say in the denial? Do they match? Do they not match? I mean, there's a lot of, and I know David just vents when he's doing it. He's writing it. It's coming out, and there's nothing wrong with doing it, because you're just going to you're going to take that work and make it more detailed in the summary judgment argument. But if you can show the AUSA they had this evidence and they clearly ignored it, or they clearly increased the standard of proof, if you can show either one of those things to the opposing counsel, they work for DOJ, not DHS. They're going to be like, I don't want to, lose my credibility with a judge because of these harebrained decisions. And the worse the denial, the better the lawsuit. If you file an MTR AO appeal, they're going to have lawyers rewrite the denial and make it better for them. If you have an officer at the ground level that just makes a completely incomprehensible decision, that's the best case to sue on because they just can't defend it.
Mhm. Perfect. So,
Yeah.
I feel when I'm writing these RFE responses, because the RFE's gotten so ridiculous, there's a lot of emotional frustration that's going into it. It's like, why are you even doing this? Forcing me to write all this. It's just an annoying experience. It really takes the fun out of practicing immigration law. I guess, I'm not a combative person. Some people might really enjoy that, going on par and fighting them and that kind of stuff. So, okay. So you've been filing these cases, you talk with the U.S. attorney, and a lot of times to resolve it. But how do you get the client to pull the trigger on a lawsuit? David, on this particular case, was the client fearful of filing a lawsuit, of both the afraid of suing the government, and secondly, the costs associated with it?
Yeah, I mean, this is interesting. This comes up for a lot of attorneys ask this. How do you get the client to file a lawsuit? And it's kind of an odd question to me in a way. I think it makes sense before you've done one of these, right? And like for him, for this first one, I was a little more hesitant. I wasn't like pushing as hard. But once you've had the experience of how this works, there is no convincing the clients, the same as telling them to appeal or do something else. I just I say, hey, listen, this is an absurd denial. To me, this is an illegal denial, and this is your remedy. If you want to remedy this, this is it. If you want to refile, let me tell you what's going to happen. They're going to give it these days. They're going to give it to the same officer, and you're going to get the same result. If you want to appeal it within USCIS and have them internally, the people who literally gave this officer instructions to make it really hard to have this be approved in the first place, okay, you can go down that route. If you want a result, then a lawsuit is the way to do it. And so I think after you do your first lawsuit, I think you kind of stop asking yourself that question, like, how do I convince? I'm not really convincing any clients. I'm giving them, laying out the options. And it's so obvious that this is the only option that's going to work for them that they're naturally going to select it.
Yeah. A lot of lawyers I work on their first case or second case, they might take the case pro bono, and I might do, if it's a sympathetic client, I might go low bono to create the relationship with the attorney and show them how it works. But if it's pro bono, if it's your own lawsuit, like with David, with the tour manager, if you file the lawsuit, you might turn a denial, you might erase a denial and turn it into an approval. If you refile, you might end up with 2 denials. So you can either have 2 serial denials, or you could just clear up your record and have CIS be somewhat afraid of you in the future, because you're actually going to file that lawsuit, and you're going to push them and make them actually follow their own policy manual. It's kind of crazy, but follow the regs, follow the rules. And I think once you've done a couple of lawsuits, and with David, in the beginning, we would do a Zoom call together, and I would walk him through the ECF, the electronic case filing. So the hardest part of the lawsuit really is the mechanical working with the government filing system, because there's nothing like it out there anywhere else. So you're not going to have it's not like INS Zoom or, some kind of form software. It's its own entity. So I kind of trained David, and now we flipped it. David's doing the writing, and he's doing this, and we can basically just split the work, get the work done fairly quickly, file that lawsuit, and then we're seeing results in 4 or 5 weeks after that.
Nice. One thing is to get clients prepared for this. Whenever I'm doing employment-based cases, which I try to do less and less nowadays because they're so time-consuming, is I just tell them, okay, so once it's filed, you may get RFE, and then you may have to sue them. So it's just part of like the game plan. That's right ahead of time. This is what we're going to do. And so I really put some of the right mindset, because one of the first cases I had that needed a lawsuit, I was so hesitant because I was unsure what it is, that I kind of wasn't positive, in that era of uncertainty caused us to go the AAO route, which was a disaster. And the AAO actually remanded the case, said our arguments are correct. Then they remanded, we wait 3-4 months and then get another RFE. So it was like complete waste of time. If we used those initial arguments to the court, we would have been approved. But AAO said, okay, remand, give them some more time. And by that time, the client company went out of business. So it was like moot. So they dragged it out for over a year until the person went out of business. And that's their way of really screwing the American public, because they were going to invest millions of dollars here. So it really just hurt America in a grand way. But now, a lot of these times we hear these, the AUSA just settles and you get a decision beforehand, or sometimes even USCIS will issue another RFE while the case is pending, and that happens too. But let's say, does it ever go to trial, or does that you ever have to go, do the courtroom drama kind of stuff, or how does that? Is that ever something that's possible?
In an APA lawsuit, there really isn't a hearing. What happens is you have what the judge and everyone will call the administrative record. So once you file a lawsuit, you're basically, if you're ignoring the MTR and the AOFA, we're not going to do any appeals. When you file a lawsuit, you basically have kind of ended the case from the government point of view, and you've frozen the administrative record. Everything in that file at the service center or the field office is supposed to contain everything on that case. That's supposed to get produced by the assistant U.S. attorney, and the judge is ultimately going to decide, is the decision, does it match the evidence? Does it contradict the evidence? Does it contradict the rules? Does it match USCIS policy? But the judge is going to look at the decision, look at the administrative record, and then either apply Chevron deference, or there's different legal analysis the judge can use. But if they don't negotiate with us, we now are getting to motions for summary judgment on some rare cases, which never really happened years ago. But the filing of a motion for summary judgment, I did it in Virginia on an H1B denial. It took me about 35 attorney hours. So from my point of view, I'm now charging one fee for the first half of the lawsuit and another fee just for summary judgment because it takes so long. Yeah. But doing all that work and filing it has caused cases to settle.
Did you freeze out? I think David's here, but Ryan will probably be back in a second. His screen froze. What about EAJA's fees? I mean, do you ever?
Because they see it and they're like, paginating.
Sorry, Brian, it froze on your end, so we lost some of it. But
yeah, sorry.
I was going to say, once you do file a case, it's rarely seen, but sometimes people get EAJA's fees, which is the court paying back the legal fees. Do you ever get there, or do you ever go for that? I mean, especially if you're doing a summary judgment motion that's going to cost that much. I'm assuming you ask for the EAJA's fees in the summary judgment motion.
I asked for them. I asked for them in the complaint. But if you get to summary judgment, if you win, then you make EAJA fee. You basically have to track your time from the beginning of the lawsuit all the way through. And we as immigration lawyers are not used to doing that.
Yeah. One of our colleagues posted that the judge kind of does an analysis and then set his own rate, and they got it for like $200 an hour, which kind of sucks when they could decide your rate, kind of like bankruptcy courts like that too. But if it's a win, it's a win at the end of the day.
Yeah, I mean, it does cap out. I think in the Ninth Circuit, it might be $205 an hour. So it's never been like what you actually deserve on the market. Yeah. But the cool thing is that the money comes out of the USCIS budget. So if you win summary judgment, you end up in a situation where you turn your bills, your time records over to the assistant U.S. attorney. They nitpick through it like they're a client, and they try to cut your bill because that money's coming out of the USCIS budget. And then you ultimately go to the judge and you say, I should get $12,000. They say you should get $7,000. And the judge actually makes a decision, no, you're getting $9,000. And then USCIS has to cut you a check. I mean, it comes from filing fees. I know it's not great, but if you got to that point, USCIS is sort of, you're playing with house money and they're already losing. So it doesn't happen very often. If the government settles the case, you're not going to get EAJA fees. But if you win a decision from the judge, then you can argue that the USCIS position was unjustified. And that's when you can get the EAJA fees.
Interesting. So that's one case. What was another case that you had to deal with that had these kind of issues?
Yes, we've done I've done two underlying cases that we've done, and then I actually am doing my first mandamus case with Brian now. And then we've done, I think we're up to two O-1s for another attorney here in Los Angeles. And this is one other thing about these lawsuits that's very powerful, is that if you are doing an extension within the US and you have somebody who's denied and their I-94 is expired at this point, you're pretty screwed. You can't refile at that point, right? And a lot of people normally don't want to leave the US, much less right now when you have those COVID restrictions and bottlenecks in all the, all the embassies and consulates abroad. So the other amazing thing is that when you win, it's like you're put back into place, right? Like it's approved.
It's a non-pro-tunc approval.
Yeah, exactly. And it's just it's an amazing resolution for that person who a second ago was freaking out and out of status. So so we've done a number of those now for these O's, and they've like all pretty easily been reopened and approved, including one really wild thing, just procedurally. I'm sure people are interested in this, because we filed a lawsuit. By the way, going back to time, I know we're saying how much time does it actually take to prepare one of these. My complaints, I probably do spend about 12 hours, 15 hours on.
Wow.
But but I go like, I mean, I'm writing this like this is the end all be all, because this is my chance to, demonstrate to USCIS like what the law is, and I want to have it on record. But anyhow, I'm probably overdoing it. As Brian's wow just really convinced me I'm overdoing it. But
no, it depends. When you're working from your prior versions that were good, everyone gets better. And what David does is he really goes into the regs and pulls out sections that we can attach as exhibits, and we can actually pull out sections of the RFE or the denial and embed them into the body of the complaint, and they're attached as exhibits. But when you start comparing their language to what's in the reg or matter of Chawath, it's not even close. And you can say to the judge, this is just crazy. And we've had bass players, actors, musicians, producers, all, tour managers, all different kinds of people. And in my practice, I've had a lacrosse coach. I've done H1B cases, but O-1s, definitely athletics. I've done an EB1A lawsuit for someone that was an extraordinary ability person as well.
Yeah, it's a decision that came out. I haven't read it yet. I posted it in the Immigration Lawyers Toolbox. Did you guys read it? What the facts were?
David has.
The Bernardo one?
Yeah,
there's some really good language in that, actually.
Brent Renison.
But yeah, it was remanded back for a decision, so they didn't. But for the totality, but the specific criteria, there's some really good language for the EB1 in that. I went and spent like an hour reading through it at Starbucks on Saturday with my highlighter, my pen, and like every single paragraph, there's like a big star and a circle, and there's some really good language in that case. But backpedaling back, a little bit to this, to this process, we draft the complaint, all these other forms that go in, and like Brian said, like the actual submission of these documents is, in the beginning, it was really overwhelming and complicated for me. And having, the people have asked for practice pointers on this, and you can have a lot of practice pointers, but having somebody like telling you where to drop each document is really what you need. And that's, that's like with Brian, I had that, it was really helpful. It would have been nearly impossible without it. But then, after you do all that, and then there's all this service and all this stuff that takes a lot of is just bureaucratic, and then
mechanical,
just mechanical, bureaucratic, step-by-step stuff. But then you either get sometimes the AUSA will reach out to you. Sometimes we try to reach out to them. It can be tricky to find the one who's assigned to it. I can actually tell you a story today that just happened with one of these. And sometimes they just send an email and they approve the case. So they said, the case gets approved and no one's even talked to. We have one that's like, they still haven't responded to us. We haven't dismissed the case, and it was approved like 30 days ago. They just went and approved it. So it's a little all over the place. But as far as other cases, we have one right now that's pending that is for an adjustment. And it's actually a really interesting case about whether, if asylum pending is a technical reason for being out of status for later on, submitting an I-140. It's
maybe later is good. That's a really big important issue of what asylum pending means. There was a Ninth Circuit case that came out. I'm gonna have separately talk to you about that. I want to see what arguments you use. That's a big thing.
So it's really, so there's a case that says if they've acted on it, then it's clearly, if they've already referred it to immigration court, then there has been action taken, and so it's not as status for technical reason. But this one had not been. So yeah, I think we have a really strong argument. But that one, I brought that up because it's an interesting example of I reached out to, you start making these connections with these AUSAs, the assistant U.S. attorneys, and I reached out to one of them and I said, hey, do you know who's assigned to this case? Like, there's a week left for the government to respond. We haven't heard anything from you guys. And he looked it up and he got back to me. He goes, actually, it fell through the cracks. Nobody was assigned to it. They just assigned it to him. He's actually a really nice guy. I'm glad that he was assigned this one. And so he asked us for an extra 30 days so they can respond, because it just slipped through the cracks at the U.S. Attorney's Office. They just forgot about it.
If they didn't meet the deadline, would it just automatically default and you'd win?
Not really. You'd have to ask the judge for a default judgment. The judges don't typically grant default judgment, but it's horribly embarrassing for the U.S. Attorney's Office. So just by filing, I don't file it. I call them or email them on day 59 and say, hey, guess what? Your deadline is tomorrow. And then they basically don't even have time to do a motion to dismiss. Yeah. All they can really do is enter an appearance, file a brief answer that just generally denies all the allegations, and they look like schmucks. So out of professional courtesy, I think telling them they're going to miss a deadline is a very good opening to negotiations. Yeah. And then, ultimately, they're asking you for continuance. You should give it to them. But if it's a mandamus case, we're banging on their door saying, hey, our client has a delay. We're creating a sense of urgency by trying to get them going. But having a good reputation with that office you're working with, and David's done a fine job, you end up working with the same AUSAs over and over, and you develop a rapport with them. They'll try to resolve cases for you.
Interesting. Now, David said he's filing more and more mandamus cases. How are those different from this? So is mandamus getting him to act on something that's pending too long?
Right.
Yeah, I don't know if yeah. I mean, I'm just doing my first ones with Brian now, but yeah. So versus most of these lawsuits we're suing, and I remember people used to throw these terms around. I was like, oh my God, I have no idea what the difference is. But like, we're suing over the Administrative Procedures Act, saying that USCIS is acting, and please correct me if I get this wrong, Brian. But when we're suing over the APA, and we're saying, hey, there was an abuse of discretion by USCIS. They're not following the law. This is the law, and this is what they've done wrong. Mandamus is saying, hey, this has not been done in a timely fashion, and so we need a response.
So mandamus, Brian, what we're saying is that there's a bureaucratic requirement that the agency has to fulfill, and they're not fulfilling it. So it's a ministerial action. So if you're looking at a 485, you really shouldn't file a mandamus case on 45, because I-485 adjustments are discretionary. But if you have an I-129, if you've paid the fee and you're applying for an L, an O, an H, whatever it is, they absolutely have to give you a decision. And if the case has been pending long enough, or even if there's a visa stuck overseas, 221G, you can file a mandamus saying they absolutely have to decide, either approve or deny this case. And then the APA also has a provision where they can't unreasonably delay adjudications. So APA lawsuits can be arbitrary capricious denials. They can also be unreasonable delays. And we argue both. We say to the judge, they're violating the APA for taking too long, or we need a writ of mandamus to resolve this because they're not doing their ministerial duties. Yeah. But those are from almost any case where you can argue. It doesn't even have to be beyond processing times. You have to show that in your case is unreasonable. So if your client has facts, and you've told the government, hey, my client has cancer, she needs her N400 approved. Yeah. You might be able to get by on less time than other people would think would be unreasonable.
You mentioned earlier that you're filing these mandamus claims on EAD's employment authorization. Congress has told the premium processing to start doing those for I-765s. They increased the fees, that part of the congressional intent, but they haven't added the more segments to it. So who knows what happens. But how will that affect it? Will people need to do premium processing instead of file a lawsuit, or?
Yeah, well, I mean, the premium processing, if they're charging $2,500, my lawsuits cost a bit more than that, but not too much. So if premium processing does come in, I imagine that CIS will start collecting the money instead of the lawyers. But for right now, I'm still getting more EAD delay cases because they can't premium process yet. So, I mean, if USCIS wants to make money instead of us, they can certainly give our clients a 2-week turnaround.
But, you know, one area that I feel people itching to file lawsuits on is in citizenship naturalization, either delaying getting the interview or after the interview not getting a decision. So that's a booming area. It's going to keep going, especially because they're backed up and the COVID-19 situation as well. It's kind of crazy. So there are 2 other topics you talked about. You talked about this lacrosse player. I think, was that the one that you just an hour ago won or something? Yeah.
Right. Yeah. It was a case out of the company's based in Colorado. The referring lawyer is based in New York. And I guess it was I can't remember if it was California Service Center or Nebraska Service Center, but they issued a denial on a lacrosse coach who had been previously approved for O-1 status. And my argument really was he was O-1 approved.
Yeah.
He's done this. He was an O-1 as a player and as a coach. What are you guys doing here? And the AUSA is actually from Colorado. He's working for the U.S. Attorney's Office in D.C., but he's from Colorado, probably a pretty athletic guy. He looked at the cases, he's just like, So he basically told me that.
I cut out again. The internet's a little bad in Colorado, but while he's out, I have a RFE. I did I-140 for an EB1C.
They were going to reopen and issue.
Sorry, Brian, you cut out, so I was just filling in a little bit.
Sure.
But you say Colorado, and then the AUSA is from Colorado, you're saying?
Right, yeah, and he basically said that the USCIS was going to reopen and issue another RFE or a notice intent to deny. And my advice to the referring, so now my job is basically done. We're going to withdraw the lawsuit in 4 weeks or 6 weeks or whatever it's going to be. But I'm working with the referring attorney saying, hey, you're getting this RFE or this NOID. I know you've used up most of your evidence responding to the RFE. Now you have to repackage it through an expert. You need to go and find a lacrosse coach at some university or some Olympic team. You need to have that person who's never met this coach before or only briefly met them, and have that person give an expert opinion that is not the lawyer regurgitating the evidence over and over. Yeah. It's, hey, someone else giving an independent opinion. And hopefully that case will be approved in the next maybe month or 2.
Interesting. One thing you mentioned, and David did too, that these people had multiple previous approvals in these categories. So like if, the L1 requirement for executive and the EB1C green card version are the same. But they won't allow you to argue that you've had multiple L's approved, but that's different than E1C. It's a different kind of thing. But when the standards are the same, how is there any consistency in these adjudications that you could differentiate that? If 3 officers already approve one thing, and the green card, it's not like O1 to EB1A, which is a higher level. The L1 and the E1C are essentially the same category. From my reading, I got to see regulations again, but I don't see any difference from those.
Well,
go ahead.
Yeah, well, so we have 2 L1 lawsuits that we filed right now for other attorneys, and these are, one of them is, this is a second extension, right? So there's a new office that got like the 1 year. They extended for the additional 3 years, and now they're extending again, and now they're saying, oh yeah, you're not in an executive position, right? So it's not only what you're saying, but it's even more egregious, because it's not even a difference. It's the exact same code.
They're questioning the prior approvals without actually questioning the prior approvals.
Yeah. So, and they actually, in this one, they did note in their decision, that whatever the memo was that came out saying, oh yeah, we can, reevaluate everything. Yeah. But the argument that I've made in the complaints about on the O1s and now for these L1s is, this is a, prima facie evidence that they have changed the standard, right, without going through the comments period, without anything, that either they've changed some sort of policy without going through the normal process, or they've elevated the standard of evidence, and all of that is abuse of discretion. And so that's the argument that we're making, but they are doing that a lot. We also, our second L1 that we're suing over is somebody who applied for an L1 for an office that was already here, not a new office, approved for 3 years. Because for business needs, she actually had to go back to South Africa, where she was originally located. And now they want to bring her here again. And so, she actually did this pro se, her application. It's exactly the same as the first one, right? I mean, the position she had in South Africa and the position she has here are identical, because it's the same person doing the same thing over again. And so we made that same argument again. But yeah, they're not admitting to this clearly, but like they are changing the standard. And it's really easy to demonstrate, particularly with L1 versus L1.
It's either a lack of training for the adjudicators, or it's a policy decision. Either one is not appropriate, and David is hammering them on it.
Thank God. Is there a way we could FOIA this? Because there's got to be emails going back and forth that shows that they're changing the standard voluntarily.
Or FOIA for the statistics, and just show, hey, 5 years ago you issued 10% RFEs. Now you're denying 55% of cases.
How are things that different? What is the process, and how much does it cost? I'm down to put some money in the group and assume on this, because this is just ridiculous lack of consistency.
Somebody is doing this right now, definitely I think for the L1, there was somebody on one of the listers who's doing this, who's like already somewhat into it. I've been planning to do it for the O1s, and I've just been like spending so much time on these other lawsuits, I haven't had time to do it. But yeah, FOIA, it's something that
I've done FOIAs, and David, I know the unknowns, like when you haven't done your first lawsuit, how hard. The FOIA itself is only a couple of pages long. And if you're making the request in your own name, it's fairly straightforward. It's all about crafting the scope of your request. And I'm happy to do it, to work with you on how to draft it. But whatever our area of expertise is, whether it's O or L or H, if we can all do one RFE, one FOIA on those, and share the response with AILA and with everyone else, then we can all kind of bootstrap it up.
I work with the nonprofit, and if the nonprofit files it based on their mission, there's no extra fees to once it's produced, because they might come at you like, well, it's $10,000 for us to produce it. You're like, oh man, but a nonprofit could do that. So I have that handy and ready to go too.
I've done FOIAs before, and I've never been charged, and they have the option to charge you. But I mean, if you're not asking for 1 million pages, like if you're actually asking for data, then they can often just produce it to you.
Interesting. So that's something we got when we go offline. We got to plan out, because it's about time. This is like so ridiculous how to deal with this.
Yeah, we do need to do that, because there's clearly, just like in the H1B scenario, there's something. It can't be coincidence that they're denying every single L1, RFEing every single L1 right now.
Yeah. And Brian, what about that H1B case you did? What was related? What was involved there?
So I've done a couple of them. I did 1 or 2 in San Francisco involving people that had their I-94s expired, like David was talking about. And in that situation, I worked with Ron Matten, who's a really good attorney in West Hollywood, also knows David. We filed the lawsuit. We filed a request or a motion for a temporary restraining order. And that got us a reaction from the judge within about 4 or 5 hours. Wow. The judge set us for a hearing on like a Thursday, and USCIS reopened the case on Wednesday and approved it, I think, the morning of the hearing.
What was the TRO for? Like not being removed or something like that? Or what was it the TRO for?
Well, the argument was that with the I-94 expired, she was going to have to leave the country. Mm-hmm. So we were arguing that she didn't have status anymore. She might have been within a grace period, but you're saying with TRO, something permanent is going to happen within the next 2 weeks or so. Yeah. And the permanency was she's going to have to leave the country. Yeah. That actually was probably before COVID. So probably now you wouldn't even be able to leave. But if you can show irreparable harm in a very short time frame, you can get in front of a judge within a week. Whereas these lawsuits, we're talking more about 60 to 70 days.
Well, if somebody's working that quickly, does that slam you as the attorney to prepare for it?
Yeah. I mean, the judges are going to call you up and set you for a telephone hearing, and you basically are having the judge pre-adjudicate the whole case. Mm-hmm. You have to show the success, your chance for success is high. So you're arguing the merits of your case, and the government just doesn't have time to get ready. So for them, they're even under more time pressure than you are. They're trying to contact the service center, get an affidavit from the officer or something. So you could lose quickly or win quickly.
Yeah, I had an immigrant visa case. I was pending at an embassy for like 3 years, and eventually the client got fed up and got a lawyer sued and did a TRO. Within like 24, 48 hours of TRO, the embassy called them and said, "Hey, come pick up your visa." I was like, "What?"
Wow.
This 3 years, their life's like just got messed up because of it. All these issues, and then
it's very powerful. But
very
you could also look like a jackass to the judge. So I've lost a TRO in the last 3 weeks, but I won the case ultimately afterwards through settlement. But I mean, you really have to be ready. You're talking to judges who clerked for Supreme Court justices. I mean, it's the real deal for us practicing law.
Yeah. I mean, that kind of is one of those things that dissuades people, that practitioners, from doing this kind of stuff, both the level of time the work commitment takes, and the environment that we're arguing. Because if you look at removal proceedings, it's so unofficial, and it's kind of like a semi, I don't want to be too derogatory, but like first when I went to removal appearance, like when I first started, I guess standing up, judge like, sit down, we don't need to stand here, and like, it was just anything kind of goes. The rules of evidence are out the window. But this is federal court. This is really serious. And the judge will like look at you like you're an idiot, like and really chew you out. Although they do that, IJs do that as well.
And I've gone online. I've seen lawyers who are good lawyers. I've looked at their work product, and sometimes you'll see track changes in the PDFs that they file with the court.
Wow.
So you have to, I mean, we're all under pressure. We're all working too many cases, but when you file things in federal court, there's just a higher level of practice required from what we're used to. But then when you look at like EAJA and the top lawyers like Chuck Cook and Jeff Joseph and Jesse Bless, they're not doing these lawsuits by themselves. They're working as a team, and they have people volunteering. And if you have 4 or 5 lawyers working together on a case, or with David and I, it's 2 lawyers. If you split the work up, it just makes it so much easier to do these big, because the government has hundreds of AUSAs. They'll bring in special AUSAs from other agencies on loan. They have limitless resources, but we know the immigration law better. So I think there's ways for us to collaborate to make it less burdensome on us.
What's recently happened with Charles Cook, Jeff Joseph, and Greg Siskin. There have been multiple lawsuits, including a recent one on K1 visas. One of my clients that joined that. And they had a hearing on Wednesday. Went so probably get a decision on it pretty soon, some initial decision. But these K1s are going to stuck up. But I joined one of the conference calls they had for the plaintiffs because my client wanted me to listen in. And it was the call itself was just people kind of frustrated and not that much new information. But it's there might be close to 1,000 plaintiffs in that case.
I think so, yeah. So when you're looking at setting up your cases, Dave and I would rather do 1,000 lawsuits. Yeah. Versus having all of your eggs in one basket, and if you lose for all of them. I've had people ask me if these cases are clumped together. And I said no. Everyone's case is individual. You get a randomly assigned judge, and you probably get a randomly assigned assistant U.S. attorney, and we all push them individually. And it's not necessarily the fastest way to get results for a big group, but you can do class action lawsuits. You can certainly do that. You can, even now, they're not even doing class actions. The last couple of big immigration decisions were membership decisions where like it was CASA in Maryland. Yeah. All their members now have protection from a court order. And you can join and you can get that protection too. So it's not a class action in the old fashioned sense, but it's certainly like a group action. And that's what, USCI is taking it sometimes, or DOS is, like for the diversity visa lottery, they won, and then DOS said, okay, whoever was a plaintiff is accepted, not the whole class of people. So a lot of shenanigans, but with the like Chamber of Commerce or membership kind of stuff, people could join to take advantage. Really bizarre way that works. That's the way of getting around the Supreme Court trying to restrict class actions. They're doing more of the membership, and I think Bill Stock and Ron Klasko in Philadelphia, they've done a lot of research and litigation on associational standing, and that's where you're able to get that benefit. But that's probably the new way. And those groups are going to make so much money off of getting more members, definitely. But that one issue you talked about, going to class versus individual, there was another attorney who was doing a lot of these cases for the travel ban, and he was making a class. And one of my clients asked me, dude, I'm like,
I don't know, maybe individually going about it, it's more quiet and they might just want to sweep it on the rug and fix it. Whereas if you make a big noise, but at the same time, if you make a big noise, they might deal with that too. It's hard to say.
I'm on the EAJA Administrative Litigation Task Force, and we're always looking for plaintiffs. And part of our job as volunteers is that we go out to EAJA members and say, hey, we need plaintiffs who match this. We need, H4, people have EADs or whatever it is. The USCIS actually tries to pick off the named class representatives and moot out their cases. So if you're willing to be the class representative, you probably get your case resolved first.
Yeah.
Because they want to get rid of you before the class is certified.
And that's why when I told my clients K1 thing, I'm like, they might just pick it apart. There's just so many different ways you don't know. And just, it's a hard decision sometimes to choose.
It's cost benefit. If that case was $1,000 and doing it by yourself was $4,000, it's a cost benefit analysis for the client, certainly.
Very interesting. So there's so much more stuff I want to talk about, but we're getting close. I don't want to keep you guys online so much. David, I want to say, for only you a couple of years, I see you grow into the scholar or immigration scholar. It's been fascinating. I really, you see the change your demeanor and like you're a professor now of this stuff. It's wonderful.
Mm-hmm.
Well, thanks to your podcast. Honestly, I always try to credit you for this. My big thing that I feel like I've learned from this administration has been a great lesson is like how to be an actual immigration lawyer, and that is looking at the law. And I say this over and over again that I think too many immigration attorneys are used to using a template, and the RFE, they get an RFE that doesn't cite 1 ounce of law, and they respond to it, and so they're just going this this back and forth. And I just remember listening to your podcast and listening to your things and you going through the regs, going through the law, going through all this. And I realized, like, why would I ever get into this fight with immigration over something that's not even the law that they're making up? Mm-hmm. And that was, I think you planted that seed for me. So thank you.
And I think what we need to do is we need to I have Westlaw. Other people can use the EAJA, what's the name? Infonet or their EAJA.
EAJA link.
EAJA link, or you could use Kurzban. There's lots of different things you can use to be case finders. So when you're doing your RFE response, David was talking about his new style. You're plugging in case citations from the circuit where your client lives, the circuit where the USCIS Service Center is, and you're arguing actual law, saying, hey, matter of EM or matter of treasure craft or what you actually need to go in there and make legal arguments and push back, because when you do, the litigation, you're pre-writing your arguments, and it's easier for us. Or if you're doing it for yourself, you're giving them a heads up, and then you're showing the judge, I've been telling them this for a while, and they're still not listening.
Mm-hmm. Okay, so one off subject that I was going to talk off there, but let's talk about really quickly now, David, to the extent you can. This issue of filing an asylum when in timely fashion. Does that hold over status for the sake of filing for adjustment of status? I did a podcast a few years back, and it actually got a lot of views, and then people contacted me and I got clients from it, but I took it off because there was a decision that came out that essentially, I didn't read the last footnote on the last page where the justices gave an out. It was a Ninth Circuit case, I think, and if I was prepared, I would have the names of the cases.
Yeah.
But the argument you made here, you're a loser. But if you had looked at this other part of the statute that says this, we would have looked at it differently, but you didn't argue this. And I didn't look at that, and I always took the argument the worst possible way for our clients, and I wouldn't file these cases. But then the subsequent case came out last year, and I have the notes to do a podcast on it, but I got too busy. But it's this issue of matter of LK, which you referenced, which says if the asylum office makes a decision and it's denied, at that point you're out of status. But potentially, when it's still pending, that means that it's USCIS delay, which keeps you in status for the sake of filing for adjustment of status. Maybe not for extension or change of status, but it's particularly says it's for like a 245A adjustment. And so you said you're filing a case based on that right now?
Yes. Yeah, so this one, so my understanding from the underlying attorney of the underlying case from this attorney is that historically, the USCIS, if you have an asylum pending case, hasn't gone to the EOIR, that they will accept that is, you know, is being in a lawful. It's not that you're being in a lawful status. It's that you have a technical reason. I don't have the language in front of me, but it says that technical reason exception for being out of status. Thus, you don't accumulate, you know, past the 6 months that, you know, which is accepted under 245K. So the case law, this is what's interesting about the case law. I think it's the Ninth Circuit decision basically implicitly says, if they have not sent this to EOIR, if they have not sent the case, then it is a technical reason because they haven't taken any action. Like the magic wording is taken action.
In immigration court, you would have the right to file 45, right?
Well, it's not. The question is like all this time is pending. So you let's say your I-589 has been pending for 3 years with the asylum, with USCIS, which is, you know, was the asylum office, and they haven't made a decision. Well, does that time count as a technical reason for being out of status, such that you can submit an I-140 and not get hit with, you know, more than 6 months out of status? And the decision doesn't come out and explicitly say that that is a technical reason, but it explicitly says if they refer it to EOIR, then it's not a technical reason.
Yeah.
Okay.
And there's a Sixth Circuit decision that I found that references the same case. And it also doesn't explicitly say that, but again, it infers that over and over, that it would be a technical reason for being out of status if you had a pending I-589 with USCIS and it had not been referred to the EOIR. So I do think we have a strong case. The language to me is pretty on point. But yeah, that's the one that we have pending right now. It was denied. They denied the I-140 based on you know, unlawful status.
The I-140 or the I-485?
I'm sorry, the I-45. Sorry, great. Yeah, the I-45. Yeah, the I-140 was approved. The I-485 was denied.
It's such a mix because this issue comes up every 6 months on the listservs, and some people get adjustments, no problem. USCIS doesn't say anything. Some field offices deny it. It's kind of like how TPS is governed. If it's admission, not some field offices. It's a wholly inconsistent thing. And just today, the Eighth Circuit, I think it was, considered TPS as admission, which is wonderful. Now
really?
the 3 circuits positively said TPS is considered admission by itself. So that's a game changer. But we have mixed results in these different jurisdictions still. Where is the Eighth? I'm not even sure where that is. I gotta look.
The Eighth, you know, my map above me has it there.
Oh, there we go.
The Eighth is everything from Arkansas up to North Dakota.
Not bad. That's a good district. Yeah.
Yeah, I mean, it's not. People are afraid of filing lawsuits in the Eighth Circuit. Yeah. I do file some of my lawsuits in Nebraska, and they actually have some precedents that are friendly in immigration.
Interesting. You know, I really want to get this stuff, at the very least, marketing and letting people know these options exist. So we'll definitely work together on this.
But David's got more cases than he wants now, right? This started off as just a couple of your cases, and now it's part of your practice, right?
Yeah. Yeah, I mean, yeah, we've got yeah, I mean, this morning I was on the phone all morning with U.S. attorneys and following up with these. So, yeah, I mean, this is the time.
Yeah, very interesting. Yeah, it's a booming area. Well, thank you guys so much for coming on. Stay online once we get off, but thank you so much. If people want to contact you, get to know more, is there email, social media, or anything you want to share with the audience?
Yeah, email's fine. I mean, I don't know if we want to put it down some notes somewhere, but dtelfer at DMT Lawyers.
I'll say it again. Yeah. I'll over you.
Yeah. dtelfer, T as in Tom, E-L, F as in Frank, E-R, at dmtlawyers.com.
Yeah. And mine is Brian Green at Green US Immigration. And my website is greenusimmigration.com.
Awesome, guys. Thanks so much. We'll probably have you all both on again. It was very fun going through this kind of more technical kind of stuff that I enjoy, especially. All right. We'll talk soon.
Thank you, John.
All right. Thanks, John.
Thank you for listening to this episode. For previous episodes and more, please visit the podcast page of our website, immigrationlawyerstoolbox.com. You can also visit the Toolbox YouTube and LinkedIn pages to catch the video versions of these podcasts, news updates, and a lot more. Immigration lawyers can also contact me to join the private Facebook page. The email is info@immigrationlawyerstoolbox.com.